YNW Melly is living in a way that's shocking for taxpayers. He's been placed in an entire housing pod by himself, a space that normally holds 50 inmates. In Broward County, the cost per inmate is about $140 a day. But if just one person takes up the whole 50-bed pod, that runs up a tab of $7,000 a day. Do the math, and that's $210,000 a month, or a staggering $2.56 million a year just to keep Melly in isolation. And here's where it gets even more intense. Melly had filed a lawsuit claiming that his conditions were cruel and unusual. He said he was locked away in near total isolation for years. No phone calls, no family visits, no private meetings with lawyers, no TV, no newspapers, and constant lockdown. He argued it was destroying his mental health and that his rights were being violated. But a federal judge just threw out his case, and not for the reason most people expected. Court records show why. The order in Jamal Demons versus Sheriff Gregory Toney revealed that Melly racked up numerous disciplinary reports while locked up. The list includes breaking phone rules, violating visitation policies, being disrespectful to staff, making threats, refusing to follow orders, and causing disruption in his housing unit. It didn't stop there. The sheriff's office also pointed fingers at one of Melly's attorneys, Raven Liberty. They alleged she helped him bend the rules on phone and video visitation, and even brought in personal items that weren't allowed under jail policies. Basically, the court sided with the sheriff's office, saying Melly's own conduct behind bars gave them reason to keep him in strict conditions. On top of breaking jail rules, YNW Melly got slapped with something even heavier in October 2023, a separate witness tampering charge. Authorities say this went down between April and July while he was already in custody. Most people don't even realize this is a whole different case from his double murder trial. And if convicted, it could carry a life sentence on its own. So even if he somehow beats the first case, he's still facing another mountain of legal trouble. Because of repeated violations behind bars, Melly has been hit with major restrictions. No family phone calls, no in-person visits, and no video visits with loved ones since 2023. The only people he's allowed to communicate with are his attorneys. And even then, one of his lawyers, Raven Liberty, can only meet him through a plexiglass barrier. That rule was put in place after jail officials accused her of bending visitation policies in the past. And get this, Melly has been completely isolated in his own housing pod since 2023. That means no other inmates around him at all, just staff and security. Now here's where the numbers get crazy. A single pod can fit 50 inmates, and the daily cost per inmate in Broward County is about $140. If only Melly is in there, that jumps to $7,000 a day. Break it down, and that's $210,000 a month, or $2.56 million a year. That's what taxpayers are reportedly paying to keep him separated from everyone else. So while fans argue about his music and legal battles, there's also a massive financial debate over whether it makes sense to spend millions just to house one person in total isolation. In November 2024, YNW Melly filed a petition asking the court for something extreme: immediate release from custody. In his filing, he argued that Broward County Sheriff's Office had committed what he called abusive and outrageous violations of his constitutional rights. On top of that, he accused the state of dragging out his trial just to keep him locked up longer. But the sheriff's office fired back, demanding the case be thrown out. They argued that Melly hadn't properly gone through all the steps in state court first, which is required before the federal courts even get involved. They also leaned on several legal doctrines, including one from a 1971 Supreme Court case called Younger versus Harris. That case basically set a rule: federal courts aren't supposed to interfere in ongoing state trials if 3 conditions are met. The case is active, it involves state interest, and the defendant has a fair chance to raise constitutional issues in state court. If those boxes are checked, federal judges are expected to step back. Melly, however, claimed that his situation was different. He said his rights to a fair trial, to proper legal counsel, and to be free from cruel and unusual punishment had all been violated. He insisted that every attempt he's made to get relief in state court has been a dead end, and that's why he turned to the federal system. Melly argued that he did try going through the state courts, but since nothing worked, he turned to the federal courts for help. In his petition, he laid out what he wanted: permission for his attorneys and investigators to visit him without barriers so they could properly prepare for trial, the ability to call his lawyers on the phone, a transfer back into the jail's general population, and the chance to reconnect with his family through calls and video visits. And if the sheriff's office refused, he wanted the court to order his release altogether. But here's the problem: his petition never addressed the sheriff's younger abstention arguments. In legal terms, that's a huge oversight, and it made his case look weak from the start. Many believe his former lawyer, Raven Liberty, just wasn't equipped to handle such a complicated battle. Thankfully for Melly, he eventually brought in a brand new legal team. Even other attorneys have admitted that switching lawyers was the smartest move he could have made. In its supplemental response, the sheriff's office doubled down. They argued that Melly's petition didn't provide any real authority to extend the statute of limitations. They said there were still remedies available in state court that he hadn't even tried yet, and they made it clear that he couldn't challenge the factual basis for his restrictions. Basically, the message was this: even if you're sitting in tough jail conditions before trial, it's almost impossible to get a federal court to step in unless something absolutely extraordinary has happened. So here's what the court is basically saying. If your case is still ongoing and there aren't any truly exceptional circumstances, then the normal legal process has to play out. A habeas petition, which is what Melly filed, usually can't be granted before trial. First, a person has to exhaust every option in state court, including appealing to the highest court in the state before the federal courts even consider stepping in. That's where the younger abstention doctrine comes in. It stops federal courts from interfering in active state criminal cases unless something extreme is happening. Melly argued that he has been trying to get relief in state court, but the record shows he only filed two real motions. One to set bond, which was denied, and one to remove restrictions on his communication and visitation, which was also denied. Beyond that, he hasn't taken his claims further through the Florida District Courts of Appeal or the Florida Supreme Court. In fact, Melly even admitted that he hasn't directly challenged the trial court's decision to deny bond or its decision to keep the restrictions in place. So the judge basically pointed out that he hasn't used all the legal tools available to him under Florida law. That's why his new lawyer, Drew Finlay, might try a different route, like pushing these issues to the state's higher courts. Until then, Melly's argument that there's no effective review left doesn't hold much weight because technically, those higher level appeals are still sitting there waiting to be used. After the state court denied Melly's motion to lift his restrictions, the federal judge made something clear. Melly's claim that he had no state remedies left just wasn't true. The judge pointed out that he could have appealed the trial court's order or even filed for habeas relief within the state court system. And since Melly hadn't actually tried those steps, he couldn't prove that the state courts were a dead end. In fact, the court noted that Melly did get some relief. The trial court ordered the sheriff's office to make better arrangements so he could meet with his lawyers, and by all accounts, those adjustments were made. Still, because Melly didn't fully exhaust all of his legal options in Florida before running to federal court, the judge said his petition had to be dismissed. The reasoning came down to the younger abstention rule once again. Back in a January 17th hearing, the judge specifically told Melly to address whether that doctrine barred his petition. But when Melly's team filed their supplemental brief, they still didn't properly deal with it. That was a fatal mistake. Reviewing the record, the judge concluded the three conditions for younger abstention were met, meaning federal courts had no business stepping in. At the end of the day, the burden was on Melly to show that the Florida courts couldn't handle his claims fairly. But by skipping key appeals and trying to sidestep the state process, the judge saw it as if he never really gave the Florida courts the chance to rule on those issues in the first place. So with all that said, the court officially dismissed Melly's petition. In the judge's eyes, it was simple. Melly hadn't exhausted the remedies he still had available in the Florida courts, and federal judges aren't supposed to interfere with ongoing state trials unless something extraordinary is happening. By not appealing bond denials, by not pushing his visitation issues through the higher state courts, and by avoiding those extra legal steps, Melly's team basically undercut their own argument. The ruling was clear. Melly's claims about cruel conditions, lack of access to family, and limits on meeting with lawyers might be serious. But because he hadn't worked them all the way through the Florida system, the federal court's hands were tied. That's why the judge sided with the sheriff's office and dismissed the case outright. This decision is a huge setback for Melly. Instead of gaining traction in federal court, he's now forced back into the state system, where the rules are tighter and the appeals process is slower. And remember, all of this is happening while he's still facing both the double murder trial and the separate witness tampering charges. Two different cases, two life or death battles, and now his legal team has to figure out how to keep him afloat in both. It's a reminder that the courtroom isn't just about facts and testimony, it's also about procedure. If your lawyers miss a step, even one small appeal, the whole case can fall apart before it even gets started. And that's exactly the position Melly is in right now, boxed in by the very system he was hoping would save him. After the petition was thrown out, the spotlight quickly shifted back to Melly's day-to-day reality. He's still locked in that single housing pod, cut off from nearly everyone, and taxpayers are still footing that $2.5 million bill each year for his isolation. Critics are now asking if this setup is really about safety or if it's a punishment disguised as special housing. The sheriff's office argues that Melly's own behavior behind bars left them with no choice. They point to repeated rule-breaking, disciplinary write-ups, and even accusations of outside help bending visitation policies. To them, isolation isn't a luxury, it's a necessity to keep order inside the jail. But Melly supporters say it's excessive, claiming the system is stacking the deck against him long before he gets his fair day in court. This tension creates a dangerous gray area. Is the state protecting the facility, or are they quietly crushing Melly's ability to defend himself? With no phone calls to family, no direct access to his mom, and only limited meetings with attorneys, some believe his defense is being crippled from the inside. And with trial dates looming, that could change everything. What's undeniable is that this fight is far from over. Melly's new legal team has hinted at taking more aggressive steps, possibly pushing appeals in Florida's higher courts. The question now is whether those moves will give him any real relief, or if the system will continue closing every door he tries to open. And while Melly's lawyers plot their next move, the bigger picture keeps getting messier. On one side, the state insists they've treated him fairly, pointing to disciplinary records and court rulings as proof that the restrictions are justified. On the other, Melly's supporters believe he's trapped in a cycle where every attempt to fight back is dismissed before it even gets heard. What makes this even more explosive is the timing. He's not only preparing for the high-profile double murder trial, but also staring down that separate witness tampering case, a charge that alone could bury him for life. 2 cases, 2 massive risks, and a jail system that seems determined to keep him on lock tighter than anyone else. For fans, it raises a haunting question. Is Melly being punished for the crimes he's accused of, or for the person he is? His fame brings attention, and attention brings scrutiny. Some argue the sheriff's office wants to make an example out of him, while others say it's all about public safety and maintaining order inside the facility. Either way, the pressure is building. Every motion, every appeal, every restriction becomes headline news. And Melly's story is no longer just about one rapper on trial. It's become a spotlight on how the justice system handles celebrity defense, isolation policies, and the fine line between discipline and constitutional rights. And with millions of dollars, 2 trials, and his entire future on the line, one thing is certain: whatever happens next won't just be a legal outcome. It'll be a moment that defines YNW Melly's legacy forever. In the end, the judge made it crystal clear. Melly's petition had no legs to stand on. The court ruled that his claims about constitutional rights couldn't be taken up in federal court because he hadn't fully gone through the state process. On top of that, the younger abstention doctrine shut the door even further, keeping federal judges from stepping into an active state case. So the final order was simple: petition dismissed without prejudice. That means Melly could try again after exhausting every state remedy. But for now, the fight is far from over. If you made it this far, make sure you subscribe, like, share, and drop a comment. Do you think Melly's being treated fairly, or is he getting singled out because of who he is? Let's talk about it below.